Assalamu alaikum, sir. Thank you for giving me the opportunity to speak. Myself, Faisal Mahmoud Rudro from Group 8. Our presentation topic is Importance of State Recognition in International Law. Now I am going to introduce about this topic. A new state is born out from an existing state or an old state which disappeared and comes with a new name or by splitting an existing state into two states. In a new state enjoys certain rights, privileges and obligation, then it must get recognition as a state, which is very essential. However, there are some minimum criteria required before a state is considered to be a state. A state must get the de jure when a state is legally recognized recognition for considering a state as a sovereign state. Political thought plays an important role in the decision whether to grant recognition or not. For recognition as a state, it must enter the into relation with the other existing states, the other existing estates. Recognition of a state. Under international law, recognition of a state can be defined as a state acknowledgement as acceptance as an international personality by the existing states of international community. The declaration to fulfill certain essential conditions of statehood as required by the international law. There are so many essential recognition of a state that such as population, territory, government, sovereignty, control should tend towards permanency. If the conditions are fulfilled, then the state can be recognized. Thank you, sir.
Assalamu alaikum. I Asif Mahmood. My point is theories of recognition. There are two theories of recognition: constructive theory, declarative theory. Constructive theory of recognition. This theory coined by Hegel and Oppenheim. According to this theory, the state is considered as an international person. This theory views that after the recognition, a state gets its status of an international person and become a subject to international law. This doesn't mean that state doesn't exist unless recognized, but in this theory, state get the exclusive rights and obligation and become a subject to international law after it's recognized by other existing state. Criticism. This theory is criticized by many of these theories. Few of them are that except the state which is recognized by other exist state rights, duties and obligation of statehood community under international law is not applicable to this theory. It also comes into confuse when a new state is recognized by some of the existing states and not recognized by other states. Oppenheim views on recognition of state. A state is and a will only be an international person if recognized as extraordinary. There is no agreement that countries have to give recognition to a state. There is no obligation on the countries. Obligation lies under international law, which will give recognition to a new state. Existing countries recognize a country as a member of the international community and believe that the state meets the requirements of international law outside the country. The theory of recognition. Declarative theory is coined by Hall, Wagner, and Fisher. This was developed in the 20th century to address shortcomings of constitutive theory. Before the recognition of the state, a new state has the right to defend as integrity and independent under international law. This theory is laid down under Article 3 Montevideo Conference of 1933. Followers of this theory consider this progress of recognition as merely a formal existence of statehood by other states. The criticism. This theory has also been criticized. It is criticized on the ground that this theory cannot be applicable for recognition of the state when the essential characteristics are fulfilled by a state then it comes into existence if under international rights and obligations are exist by the state. Then declarative theories applies, but when the state gets the legal rights of recognition, then constructive theory applies. Thank you.
Assalamualaikum sir. My name is Reja Humaira Payal. My ID is 194146993. Today my presentation subtopic is political recognition of state. Political act in recognition is used to support or to reject state or a government which is new in an international community. Mixture of fact and law and the establishment of particular factual condition and compliance with relevant rules are the process of creating new state. Criteria of statehood is laid down in the Montevideo Convention, which provide that state must have a permanent population, a defined territory and government and capacity of conduct international relations. Recognition of state in political act based on interest and assessment made by state in individually but legally agreement are important. And that is my presentation. Thank you so much, sir. Assalamualaikum.
Assalamualaikum sir, I'm Asmaul Husna. First, I would like to thank my course teacher Khalid Rahman sir for giving me this opportunity to present my presentation. My presentation topic is withdrawal of recognition. A state may withdraw diplomatic recognition of another state or simply refuse to deal with that other country. After withdrawing from all diplomatic relations with that country, such as embassies and consulates, and requiring the other country to do the same, and the state will appoint a protecting power to represent its interest in other state. Second point, recognition of government. Besides recognizing the state, states also can recognize the governments of states. This can be problematic, particularly when a new government comes to power by illegally means or when existing government is in power by fixing an election. States once formally recognized both the government of a state and the state itself, but many no longer follow that practice, even though if diplomatic relations are to be maintained, it is necessary that there be a government with which to engage in diplomatic relations. Countries such as the United States answer queries over the recognition of governments with the statement. And another point is recognition of belligerency, the condition of being in fact engaged in war. A nation is termed a belligerent even when resorting to war in order to withstand or punish an aggressor. A declaration of war is not necessary to create a state of belligerency. For example, the United States and the People's Republic of China were belligerents during the Korean conflict, although both parties avoided characterizing the hostilities as war. And another point, recognition of insurgency. The recognition by existing states the de facto authority over a large territory of the rebels is said to be insurgency. In case of insurgency, the rebels or the insurgents occupy a large part of the national territory which was formerly governed by the present government, and if they were capable to control over that occupied part, then the existing state can recognize. Thanks for listening to me.
Assalamualaikum sir, I am Monica Rahman. Thank you for giving me opportunity. Today my topic is forms of recognition. De facto recognition. De facto recognition is mostly granted to governments. It is a temporary recognition of a state. This can be conditional or without any condition. This mode of recognition is granted when a new state holds a sufficient territory or control over a particular territory. but the other existent state consider that when they do not have enough stability or any other unsettlement issues, so we can take it as a test of control for newly formed state. The UK first recognized Soviet government as a de facto recognition in 1921 and later recognized as a de jure in 1924. De jure recognition is given to a new state when a new state fulfills all the essential characteristics of a state. De jure recognition can directly be granted to a state who have or have not granted de facto recognition. Newborn state granted the permanent state as a servient state, though de jure mode of recognition. Difference between de facto recognition and de jure recognition. De facto recognition is a temporary factual recognition. De jure recognition is a permanent and a legal recognition. De facto recognition is a granted to a state when it fulfills the essential condition of state. De jure recognition is a granted to a state when all the essential are fulfilled along with the permanent control of the essentials. De facto recognition is the primary step to grant de jure recognition. De jure recognition can directly be granted without de facto recognition. De facto recognition can easily be revoked. De jure recognition can never be revoked. The states having de facto recognition cannot enjoy the diplomatic immunities. The state having de jure recognition can enjoy the diplomatic immunities. The state having de facto recognition have only few rights and obligations against other states. The states having de jure recognition have absolutely right and obligations against other states. Thank you, sir.
Uh, uh, Hello everyone. Hello teacher. Thank you. Hello everyone. Hello teacher. Thank you for giving me this opportunity to speak. My topic is conclusion. The reconstitution of the state an essential product so that the state can enjoy the rights and the privilege and independent community under international law. The reconstitution before both provides right and privilege obligation. When a state gets de facto registration, its privilege and obligations are less, but when de jure recognized by the state, it gets absolutely rights, liabilities and privileges. The recognition of the state has some political influences on the international platform. There are many situations where powerful states create difficulties in recognition of a newly formed state. This can be withdrawn when any state does it fulfill condition for being a sovereign. Recognition may vary from case to case. De jure recognition can be given directly to the state. There is no necessary of de facto recognition, even if de facto is considered as the primary state of achieve de jure recognition. Thank you everyone. Thank you teacher.